Right, well, I think I'm going to officially kick this webinar off. Welcome one and all to this particularly special instalment of the 3PB Family Law Brunch series. It's not particularly special because I'm one of the panelists or because it's a bank holiday on the horizon tomorrow. It is, however, particularly special because I'm joined by David Nicholson of DNA Legal. They are a company that no doubt everyone is familiar with in their practices. But I will say this of David: he is the managing director of DNA Legal, and he founded the business some 20 years ago with the purpose of delivering toxicology and DNA testing that offers a point of truth for clients. As an industry pioneer, he was the first to introduce nail drug testing in 2012 and PEth testing in 2013 in the UK. In 2014, working with Kafkas, he developed a unique method of testing in care proceedings that can identify exposure to drugs from use. In 2017, the High Court recommended the approach DNA Legal take is adopted by all testing labs. Welcome, David. Good morning. Okay, well, thank you, those of you who've taken part in the poll. Just to reassure you, that is for educational purposes only. It's not for direct sales purposes, if you were worried about that. And also, thank you to those of you who provided questions in the chat box in advance. We will do our absolute best to answer as many of your questions as we possibly can, but can't promise all of them will be answered. You can, of course, contact me and after the event, and my email address will be available to you at the end of my presentation. I should also say that I think our presentations will be available after the event. David, is that the case for you? I think I can see you nodding.
Yes, that's correct. And good morning, everyone. They will be available after the presentation of going.
Thank you, David. Okay, this is a play of three parts, really. I'm going to go first as a refresher on Part 25 applications, and that's going to take about 15 or 20 minutes. And then David is going to go into his presentation and give us an insight into toxicology. And that's something that, of course, we deal with most days in our children proceedings, or our children cases at least. And is also something in particular that there are many pitfalls for legal practitioners. So I hope David is able to help us a little bit there. And also I hope that part 3 is that we're able to open up the discussion and have a chance for questions as well after that. So without further ado, I will begin my part of this. Just bear with me. Well, I hope you can all see the slides up in front of you. I'm going to talk, first of all, about the law, which I hope that we're largely familiar with. And if there's any key takeaway from this presentation, I want you to remember the words necessity. And I also want you to remember the words delay, because those are things that are present not just in the law as it is at the moment, but also, and I'm going to put it this way, as part of the policy trajectory coming from the higher courts. So I'm then going to move on to talk about where we're going and some of the practicalities about making Part 25 applications. And then, of course, we'll move on to David. Okay. Part 25 of the Family Procedure Rules, in particular, Part 25.43 and the Practice Directions, 25B and 25C, absolutely key. But crucially, the instruction of an expert in family proceedings must be necessary to assist the court to resolve the proceedings. And no doubt you will be familiar with the addition that was presented in section 13(6) of the 2014 Act, which adds the word justly to the instruction, or potential instruction of an expert. Remember section 13, subsection 5 of the 2014 Act as well, which is the Children and Families Act, by the way, I should say, that there should be no expert evidence without the permission of the court. I'm just going to talk briefly about the additions of section 13(7), which are the considerations that the court has to give when thinking about whether it should admit expert evidence. I should also say here that there is a slant towards children work in particular, and a slant towards care work as well, in particular in this presentation. If you are more concerned or equally concerned with financial remedies or talata matters or even inheritance matters, then please refer to, of course, the rules, but also the efficiency statement as well that is available to you, that provides some important information in respect of making Part 25 applications. So the focus here is on children work primarily. Just to take a canter through the considerations that the court will have, of course, the impact on the child of any assessment or examination is absolutely key when thinking about medical examinations, psychologists, and so on. What impact does that have on the child? What issues the evidence would relate to? The questions the court would require the expert to answer, and that's very much specified in, or prescribed, I should say, in Children Act proceedings by the court. What other evidence is available? Is there other evidence before the court that would not necessitate further expert evidence? And whether that evidence could be given by another person. This is an absolutely key one, the next one, which is the impact on the timetable. It's frequently the issue for the court, and something I'm going to return to later in respect of when or whether we make applications for expert evidence at all. There's also the cost and any other matters prescribed by the rules. In respect of cost, the default position, particularly in care, is that the costs are shared equally between the parties unless the court directs otherwise. So I talked about delay before, and I'm going to refer you again to the President's Memorandum in 2021. In that memorandum, the President cites Kennedy and Cordia, which is a Supreme Court case from 2016. And it says that the governing criteria is whether the evidence will assist the court in its task. And of course, there is a higher standard in the matters that we all deal with, which is that of necessity. And you can see, I'm sure you can read for yourselves the remainder of that, but I wanted to emphasize the point of necessity being the standard. The court will refuse to authorize or admit the evidence of an expert not based on any established body of knowledge. And that's an important point to pick up on, and something I'll return to shortly. This is the first of two warnings. Be extremely careful when thinking about the instruction of the expert, about who we're instructing and their CV. I'm sure that the Reece parental alienation case that I cite up there will be familiar to you. This gained press coverage, national press coverage at the time, more around the issue of parental alienation in and of itself. And there are academic debates going on actually at this time about whether parental alienation even exists, or whether it is in fact a tool for domestic abusers to continue that abuse. I take a slightly more nuanced approach to that. But in any event, this case involved the instruction of a psychologist presented as an expert. And really the inappropriateness of that expert's expert evidence, it is always a matter for the court. I would also refer you to the LCC and VB case from 2023, which is where the expert in that case, who was actually a paediatrician, came under some seriously robust criticism for essentially making the evidence fit their conclusion. And I would really advise you to refer to that case, because it is damning of the expert. And I think it's incumbent on all of us as practitioners to make sure that we're scrutinizing the CVs of the experts that we're proposing should be instructed. There have been many cases over the course of 2023 where the experts' conduct and actually those who instruct them has come under some serious scrutiny, and that seems to be the policy trajectory of the courts when considering whether to admit expert evidence at all. Which leads me on to this case, which some of you may also be familiar with. It's Northamptonshire Council and the mother. This is a 2024 case, and it is a decision of Mrs. Justice Leedon. This involved something that I think is very much what I'm going to call a bread and butter situation in practice, which is where we're looking at vulnerable clients in care proceedings who may have some cognitive and or capacity issues. And this was about the instruction of an expert psychologist to assess the mother in the case. And the solicitor for the mother, poor man, had taken what he called a belt and braces approach to making an application for the instruction of the psychologist. Having met the mother, the solicitor then decided he would seek permission to withdraw the application, but Mrs. Justice Leven chose to give a judgment on the issue, dismissing the application. And she was highly critical of the solicitor, but not just the solicitor for the mother, but also the guardian for taking a neutral approach rather than taking a more robust approach in whether it was necessary to instruct a psychologist. She also highlights in that judgment making use of toolkits and it being incumbent on all of us as practitioners to make sure that we use simple language when dealing with vulnerable clients and so on. But I think it's a really important takeaway that the court will require specific submissions on why the legal test is met. And it seems to me from that judgment that vulnerability is not enough. So I think as practitioners, we need to be thinking very carefully about when it is appropriate and when it is necessary to make these applications. And I think no doubt we have all heard the guidance from March 2022, which is make every hearing count. And that means maximising court resources and not making applications where they are not necessary. I'm just going to deal a little bit with practicalities. Timing, absolutely crucial. And you'll find in the rules under the Family Procedure Rules 25.6 that in care proceedings, certainly applications should be made no later than the FCMH. And in private children proceedings, no later than, that should say for FHDRA, actually that's a typo, than the FHDRA in finance proceedings, actually no later than the FDA, but that's a different matter. So with that in mind, I realise, and I think I understand that it's not always practical to make those applications, but that is at that time, but that is certainly what the rules indicate or what they say. You should always refer to Part 18 in respect of the practicalities in respect of procedure for making an application, the application notice, etc., which should include the field of expertise, the name of the expert where that's possible, that's not always possible, the issues to which the evidence relates, and whether the evidence can be obtained from a single joint expert and the questions for the expert to answer. Of course, you'll know that the court can make and frequently does make a direction for a single joint expert. In respect of single joint experts, I'm just going to skip to the bottom of the slide, which indicates that you should really take a look at PD 25C, which I've referred to, and in particular paragraph 3.1043. Do look at that when considering the instruction of a single joint expert and in respect of preliminary inquiries being made of the expert. And also what's to be included in the letter of instruction as well, which is also clearly set out in the practice direction. I then indicate on the slide other things which, in terms of practicalities, attaching a draft order and also remembering our general duties under GDPR as well when providing information to the expert. What happens if the court grants the instruction of the expert or 25.8 of the rules will tell you what will happen after. And as I've said before, in children proceedings, the court is required to be prescriptive about the questions. It's not strictly required to be prescriptive about questions in financial remedy proceedings, actually, but it typically, frequently is, as those of you who do that sort of work will know. Directions will be given for the date for the expert's report, and the questions will be approved. I think I've already actually discussed in the previous slide about considering PD25C and the instruction of a single joint expert. It deals with the lead up to a permission hearing, and I think that's really important to reflect on. If you find yourself in that situation, which you no doubt will. Okay. As I said at the beginning of this presentation, we need to reflect on the policy trajectory at this time, which is towards only admitting expert evidence where it is necessary. And I ask you to reflect on that recent Mrs. Justice Leaven judgment about whether it was necessary to have a psychological assessment, which are quite often applications for which are quite often made as a matter of course in care proceedings. But think twice after that judgment, I think, and really reflect on necessity and the potential for delay in our cases when making applications under Part 25. I'll deal with questions at the end of both of our presentations, but I'm now going to pass you over to David, who is going to present on toxicology, and I am fascinated to hear what he's got to tell us.
Fantastic. Thank you very much, Sam, and welcome everyone. I'm just going to share my screen here, make sure you can all see this. If this is working, we'll share it like that. Perfect. So, so my name is David Nicholson. I'm Managing Director here at DNA Legal. It's a real honor to be with you this morning on this brunch session. Today, we're talking about the fundamental misunderstandings of expert reports. So everything you've been through just now with Sam is the importance of who to instruct and also how to do that instruction. Today, we'll go through a little bit about some of these myths and some of the misunderstandings around toxicology, from hair growth rates to low, medium, and high, to really looking at, does a negative test really mean that no drugs have been used? So we're going to cover all of that off for you. But for those who don't know us, we're DNA Legal, part of DNA Worldwide Group, and have impacted the lives of over 12 million people since 2004. During that time, the way we've grown and what we like to do for you is to make the process really, really simple. So when you work with us, you have a client manager, and they're going to come on board and support you with everything you need for your testing. A lot of clients simply provide us your client's phone number. We organize everything and complete the entire process. In terms of the landmark High Court case in 2017, as a business, we've actually approached care proceedings from a forensic testing aspect. We've approached it from looking at it from the fact that you've got lots of evidence and the drug results are only one small part of it. And for that reason, the approach that we take was recommended to be used across the industry. But all of that is kind of pointless if you can't understand the results, and that's part of what we're here for today, and also why we developed a very simple 8-page report when 90% of your questions are answered on that very first page. So before we delve into some of the misconceptions, let's start with the very basics here. And it's the fact that when you're looking at drug testing, head hair is the best option. And the reason for that is it allows you to provide a pattern of use. When the first hair testing was done back in 1999 in the UK on some criminal cases, the reason why it was so important and so valuable was because it could give a build-up What's the history of use been? Not necessarily what the numbers have been, not looking at what those numbers are saying, but actually looking at, was there consistent drug use? Was there an increase in drug use, or was that drug use decreasing over that period in time? When we come to alcohol testing, exactly the same thing. Head hair is the preferred option, but with alcohol testing, it's always essential that that's coupled with blood testing. In most areas now, the PEth test, the phosphatidylethanol test, is the one you use. If you're using anything other than phosphatidylethanol, it's very easy to challenge those blood results. We have separate webinars that we do on that. So the basics of testing, ultimately, someone uses a drug, that drug metabolizes in the body, and that metabolization process is basically the body breaking down that drug. And it's those breakdown products that are deposited in hair and nails. The reason why we want the metabolites is because some of those metabolites can only be formed in the body. So if we find them in the nails or in the hair, we can conclusively confirm that that person had actually actively used the drug versus actually being exposed to the drug. When it comes to the way that drugs are incorporated, it comes through the blood vessels, and as the hair follicle grows, these little metabolites are bound into the hair like this. This works really well for drugs, and it takes about 2.5 weeks from the time someone consumes some drugs for those to be detected on the top of the surface. For alcohol, it's a bit different. Alcohol is absorbed through sweat and sebum into the hair. So you could have a client who's never drunk in their life, who goes out for a weekend, has a lot of alcohol, and their entire length of hair would be covered in the alcohol. That's one of the reasons why segmenting of hair is predominantly focused on drugs, because it can give you an accurate picture. A couple of things to consider here on this point is these little metabolites, they attach to and bind to the melanin, the pigment in the hair. So if you have a client who's got dark hair, it's going to be easier for those metabolites to bind to the dark hair, and therefore their numbers in your reports are generally going to be higher than someone with blonde hair. It doesn't mean they've used more. It simply means it's easier to detect those drugs in darker hair than it is in light hair. That's why you should never compare two people in a case between each other. A blonde person, a brunette person can have very different levels in their hair when consuming the same amount of drugs. So that's kind of a whistle stop through the basics of testing. Now we want to pick up a few little myths. One of them is, I'm going to instruct a 3 centimeter hair strand test because I want to get 3 months history covered. Now, all testing by every laboratory and by the Society of Hair Testing is based on average growth rates. And at 1 centimeter per month average growth rate, the 3 months therefore does need a 3 centimeter segment. What's not often looked at is the fact that most people, therefore, are not average. Only 1 or 2% of people will actually have a hair growth rate at 1 centimeter per month. So a 3 centimeter head hair sample, if we say here is an example from our report, was analyzed for the presence of drugs. This would typically range, in this example, from the start of January to the start of April for 3 months. However, if the donor had a slower hair growth rate, that 3 centimeter segment could actually cover from the start of October last year, October 2023, all the way through to the start of April 2024, so covering 6 months. If they have a fast hair growth rate of 2 centimeters per month or so, that could cover as little as from mid-February to the start of April. So when we look at here and we look at this growth rates, what we can look at is saying that 10, 15 years ago in your reports, you would never have seen dates applicable to each segment, because the toxicologist considered that this was something that would be confusing. It was introduced on the demand of the courts as saying we need to simplify reports. And it does simplify it, provided you can also appreciate that in this example here, if it is on average, then that 3 centimeters will be covering 3 months. But it could also be covering 4 or 5 months, or as little as 1.5. It's why it's really important that when you're instructing the cases with us or with any provider, that the full information on the background of the client is disclosed. We take a statement at the collection, and we say in the last 12 months, what drugs or alcohol have been consumed. Because if your client in this case was using drugs at the start of November 2023, and we're doing a test here in mid-May, trying to cover just 3 months, and they don't declare this, those drugs, if they were using them to a high enough level, would still show as positive in the most recent 3-month segment. There is a possibility that that is the case. By declaring accurately what was used prior to the testing period, our toxicologists are able to state, are those results consistent with what's been declared or not? So growth rates does play a big part. And the purpose of the growth rates and the purpose of testing as well, it is segmented. It is designed to show what is the trend in use. Timescales are indicative, but they can always have variability in them. So if your donor is saying, I didn't use those drugs in February, but I might have used them a month and a half before, that could be correct. Equally, based on the actual results, we're able to tell if that isn't correct. So do speak to us on any of those cases. The next point that we have that is a really common one across the industry is the factor of what is low, medium, and high. There's a lot of misunderstanding that people think that low, medium, or high actually means someone is a low, medium, or high user of a drug. It's actually not possible to correlate drug dosage or drug use to the levels detected in hair. But in accordance with industry practice, there was an indication of how much drugs were detected in the sample, and is this low, medium, or high? It's not saying the person has used that, but it's saying overall, those are the levels that we're seeing in the hair. So some points to consider here. Every lab will have different levels for what they class as low, medium, and high. Number one, it's based on how each lab actually does the testing. Every laboratory is going to extract those drugs from the hair in a different way. Different chemicals, different extraction techniques, all of the science means that what they actually detect in the hair will be different. Every set of samples is going to be different. Every set is going to vary. And it'll be impossible to have a unified level due to the processes between the lab. For instance, if one company is testing 1,000 people who all happen to be very high users of cocaine, that will give a different range of low, medium, and high to another lab that could be testing 500 people who hardly use cocaine. Something to consider. It's not giving you, are they a low, medium, and a high user? It's giving you an indication compared to the lab. The way you metabolize drugs, the way you absorb drugs, and the way they're extracted all have a big part to play in that. It does give you insight, though. It can give you an indication, and that's why it is a useful tool to have. It simply works, these low, medium, and high levels, by taking all of those tests that the laboratory has done, and it breaks them down and saying, for the bottom 25% of my results, I'm going to call those low. What range is that? And that could be 0 to 5, 0 to 6. And any sample that then falls into that range gets classed as low. The same with the high results. And then anything in between is classed as medium. So it means that 2 people can ultimately use the same amount of cocaine, and their hair test results can be different. One may show as a low-high result, and the other one may show as in the top range of a low result. 2 people can give the same hair test result having used different amounts of cocaine. Again, it's an indication, something to really be aware of. And the ideal way to use this, again, as with all tests, is to look at the pattern. Is that pattern increasing, decreasing, consistent, or is there cessation? The toxicologists themselves, they won't look at the number to start with. They'll look at what the pattern is. What is the pattern showing? What are the metabolites? Only after they've looked at all of that information do they look at the number, And then finally, they'll look at your donor's declaration and go, does this all align to what the donor has stated or not? Typically, as individuals, non-scientists, we'll go straight to the number. And then we can get a little bit confused and it can mislead the case. The other fact we have to look at when we're looking at these low, medium, and high levels is they change. The purity of cocaine pre-pandemic was in the 20 to 30% range, around 22, 23%. Post-pandemic, that purity has increased significantly to about 70, 75% on average. It means that what you class as high pre-pandemic now has to be significantly more higher levels to be classed as high post-pandemic. Those levels have to be updated, because if you don't update those levels by the labs, suddenly everyone is a high user of cocaine, when actually the cocaine itself has increased in purity. The next point, does negative mean no drugs are used? Quite simply, a negative drug test means the drugs were not detected above the concentration the lab has set as being as positive. It does not mean no drugs were used. There's cutoff levels that are applied by some laboratories, and a cutoff is issued based on traditionally the European workplace drug testing standards. And this is where you say those cutoff levels will confirm a positive result above that level. These are designed for workplaces. Only in the UK are workplace cutoffs applied to forensic testing, such as child custody cases. In a workplace scenario, you don't have all of the great work that you do, the social service team does, and everyone does to actually look behind the scenes here and actually look at what's going on. In a workplace, you need to be able to fire someone for drugs without having any of that background information. So the levels are looking at chronic use. The question really when we speak to the judges and the courts on is, are you looking for chronic use of a drug, or are you looking for occasional or infrequent use of the drug? In most cases, it's actually you want both. You want to know what's actually being taken, and then you can use that as part of your evidence. Another myth, every drug test from every company is the same. Unfortunately, it's not, and the reason for that is every lab is different. Each use their own operating procedures and methods. All are designed to provide a result and absolutely detect, is a drug detected or not? But past that point, every lab will do things a little bit differently. One example here is the ability to determine the difference between active use of a drug or drug exposure. Some labs just test the parent drug. There's been a case where one laboratory has just been testing cannabis to say, has cannabis been used or not? When the metabolite of that cannabis, carboxy-THC, has to be tested in order to confirm active use in line with the Society of Hair Testing guidelines. That's one point. The second point is drugs can get into the hair through many reasons, through smoke, through sweat. And the first step that when you get a hair sample into laboratory is you need to decontaminate it. You need to get rid of all of that exposure that's come in. So in forensic testing, you actually wash that hair and then you test the wash. It's not done routinely by anyone else in the hair testing industry in the UK, in the top 5 companies for family law cases, because it's more expensive. But why you do that is because by testing the wash and having those metabolites, you can rule out, was this passive exposure or contamination? Had someone actively used the drug? For adults, that's really key to determine that before you get to court. And a lot of cases are coming up where we're actually doing this for children cases, where children are being tested to say, what environment are the children in? Are they in places where parents are aware that their care is exposing them to the use of drugs? Are people who are smoking cannabis doing that around the children or not? It means we get an extra data in our reports. For most laboratory reports, you're going to get one bit on the graph if you get a graph in your report. If not, it's going to give you a level that says this result shows that cannabis has been detected at whatever rate that has been detected. With DNA legal, we also tell you, well, what's in the wash? Unique to us, you get to see, actually, this is a high concentration of the drug in the wash. When you combine this with the metabolite, we can say in this case, there's a high chance that this person's results were from passive exposure to the drug rather than active use of cannabis. That is not always the case. There are a lot of times where actually the wash is not high or has hardly anything in it. Instead, those results are all in the sample itself. The next point we're going to go on to, and this is a whirlwind tour, which is why you're going to get the slides and you're going to get everything else. And that's how it works. So above the alcohol cutoff always means chronic excessive use. Does it or does it not? Well, in the UK, we use a cutoff level for ETG of 30 picograms per milligram. And I'm raising these points now because the forensic science regulator is asking for criminal cases that you include the certainty, the measurement of uncertainty in those reports. That is not a requirement in family and care proceedings, so you don't see it in the reports at the moment. But every test you run in a laboratory, you can get a variance of 20 to 30%. As a result of this, if you have a cutoff of 30, with DNA legal, if that result is anywhere between, say, 25 upwards, which falls under the positive cutoff for chronic use, and you test it tomorrow, it could fall as 31 or 32 and be over the cutoff. For other labs, they have even wider ranges. If you test anything under that, again, it could fall positive. And equally, if someone has a range of 32, 33, 34, 35, and you test again, it could actually fall under the cutoff. We raise this purely because we've seen a number of cases where that number of 30, if it's 31, 32, 33, the judge is being very different on that case compared to if it's 28 or 29, when really you can't get that precise around that cutoff. We'll now include in our reports for you something saying it's above but close to that cutoff. So you can't demonstrate repetitively that use of the drug. We can't absolutely unequivocally say that chronic alcohol abuse has occurred, but we can say it's a high level. As soon as that level goes above the 38, 39, if you have clients like that, that is very clearly chronic abuse. But if you're in that range around 30, definitely check out those reports again. Another question we're seeing is ultimately how useful is the segmenting a hair test for alcohol? Couple of things we see here is there's two answers to that. Technically, just like in drugs, you can segment and cut hair into any length you want. The problem is, how do you interpret? As I mentioned, alcohol absorption is very different to the absorption of drugs. Alcohol, when consumed, is absorbed through sweat, through the entire length of the hair. And the levels of that ETG tend to increase closer to the scalp. So segmenting hair for alcohol can be useful if your client has abstained completely from alcohol and you want to prove that. Then it can, in a certain percentage of those cases, confirm a decrease. However, you could get the same information by doing an overview and PEth, which ultimately would be a significant cost savings to you. Now, one myth that many of the clients have is, I'm going to bleach my hair, it's going to help my case. This lady read online that if she bleached her hair, no one would be able to find drugs. And as a result of that, she would have a higher chance of having her child back. In this case, when she bleached it, it actually, because of the natural cycle of how hair is absorbed and bleaching occurs, drugs are absorbed into hair, showed an increase in the most recent segment of amphetamines, albeit at a small level for amphetamines. She then did a secondary test a number of months later, and this gives you an indication of what those levels are. It went from here having a lower amount of the drugs in her system, increasing and showing higher use. Everyone in this case thought she'd actually moved from the drug that she was on before, cocaine, and now she was on amphetamines. We hypothesized with her on what those results would have looked like had she not have bleached her hair, and you would have seen results like this. A high level of amphetamines. When you combine those with the most recent segment, this shows that absolutely perfect reduction in use, exactly what you want to see for someone coming off the drugs. Unfortunately, she damaged the history. She erased the past, and so she wasn't able to demonstrate that decreasing use of drugs. when people do try to alter a test, and I know everyone on the call is very used to that, but when you do try to alter a test, it has an impact because it delays the period of that time of that case. It means it normally takes several more months to get the evidence you need. This person was making big changes, actually. She was actually reducing her use, but couldn't demonstrate it because of the action she had taken. Finally, before we go into a bit of a question time, we wanted to go through that simple report. 8 to 10 pages plus an appendix. Page 3, which is your first main page, it's going to show which drugs are positive, is it alcohol excessive, and are these results in accordance with declared use. All of the points we've raised about prior use of drugs, cocaine lingering in the drugs, in the hair color, hair growth rates, all of this stuff that has an effect is all covered off in your expert report in the detailed section should you need it. But ultimately, you should have something like this on that first page. The results demonstrate the active use of the drug between these periods, and results could be consistent with the declaration or not. That is what we're looking for, something as simple as possible to give you everything you need to deliver the advice and the support for your clients. We've recently taken that a step further to support everyone and provide what are the recommendations for further testing. So your client, you can understand and you can present back to your client what needs to happen next to show their journey. What we do is a small part of the process. We spend a lot of time taking care with how we meet your clients, how we greet them, how we are when we're taking samples, extensive training programs that go through, but ultimately we're there to help them show a change in their use of drugs and alcohol. And by having all the information from them, by having that clear instruction, which we're able to help you with and give you any guidance you need, we can best represent the truth of what is actually happening. And that's what we're here to do. So from me, that's everything. And we'll go on to some questions.
Thank you very much for that, David. It was fascinating. I am conscious of time, so I think we better look at the questions that people have put in the chat box. Is there anything that you can pick up on from there?
So I think there's a question in here. The question is it possible for cocaine to linger in a donor's hair months after use? That's a great question. So when you consume certain drugs, especially cocaine, they bind to the hair very easily. You also have the fact that your hair is 15% of that hair is in a growth state, that in a non-growing state, sorry. So it's actually sleeping. So this means if someone used a high amount of cocaine, it can take about 6 months for those drugs to show negative in the most recent hair strand tests. So the cocaine doesn't actually necessarily linger there, but what it does do is the cocaine is actually trapped in the hair that is not growing at levels that are so high that we actually need to, that it can still show as positive. We have some great techniques to be able to tell if that has been from prior use 6 months ago, 3 months ago, but that's where that declaration is really important to come in. Just looking at any other questions here.
Yeah, thank you for that. Oh, sorry, David, you carry on.
Yeah, so the other one from Kim is, can you explain why alcohol testing that both hair and blood is required? The guidelines for testing alcohol is that you should always test hair and blood because you get different markers. There's many things that can affect a hair alcohol test because of the way it's absorbed. It's not the same as drugs. So the recommendation is you should always test more than one matrix, and that's where the blood and the hair can give you the most recent period in blood, and then the longer term history in hair. And it's quite easy to do that, which is great. Another question is, can ingestion of bodily fluids from a cocaine user result in a positive test result for cocaine use? There are cases, and especially in instances of sporting industry, where there is known intimate contact between two people who've used drugs. One person who's using drugs has had intimate contact with another, and there has been transference of those drugs. It's typically in urine and saliva that those are tested and come back as positive. So it would have to be quite an excessive and prolonged period of intimate contact over many, many days for that to potentially affect hair. So another question has come in about the difference between suggest and demonstrate, what those words actually mean, so that we can explain the difference. So suggest is when we're not so certain. It's like there's different levels of confidence that we have in why these results are what they are. They suggest use, but it could be exposure, versus demonstrate use means we're really certain actually that this person has used the drug. So it's just the terminology to give a flavor and a articulation to you for that report. It's not a black and white science. There is the results, and then you've got the why those results are what they are. And what we're looking to do is provide more or less emphasis to the court on how likely we think that scenario is. A question on alcohol testing here. If a client consumes low alcohol drinks only, is there sufficient alcohol in the drinks to affect the results? It would depend on how much that person has been drinking, because we're looking at the percentage of units. So for an alcohol, positive alcohol, for someone who's chronically abusing alcohol would need to, for women, drink equivalent of about 2 large glasses of wine per day, and for men about 3 large glasses of wine per day. I do know many people who go out at the weekend and drink that in vodkas and other drinks and wine, and just do that on a weekend, and that can also tip someone over into being chronically abusing alcohol if they drunk the equivalent of the week in a weekend. A question about care proceedings here and several different providers being tested. Every laboratory will have a different way of doing its tests. So you're looking at, in each report, if you are looking at multiple reports, what is the trend showing? If you've tested by another laboratory and you come to us, then we will interpret the previous laboratory's results and consider those in your most recent report. The way we look at it is we're going to give you a story, and if you test with us 3 times, we'll give you that story. Each test will be improving the information we can share with you. If one of those tests is by another company, if you provide that, we can help you and help provide that information. But yes, if in one laboratory could have the level 200, 150, and another could have 1,000, 500, 250, those results are the same, just the numbers are different. It's always about the pattern. Is that going up, increasing, or decreasing? When it comes to Afro-Caribbean hair, one of the questions is, what is the difference with Afro-Caribbean hair? And it's a lot thicker. It has a different hair growth rate, and it's much darker, so it has more melanin in it in general. Therefore, when we interpret Afro-Caribbean hair, we consider those in our reports. Again, it's why that even if someone who's got Afro-Caribbean hair may show as a very high user or a high level in their hair, it doesn't mean necessarily they're a high user. It means they have a high level detected because of the fact that their hair can be thicker and have more melanin. PEF testing. The question is, how reliable is PEF testing? And PEF testing has been one of the most reliable tests. It's over 99% sensitive. It's not affected by age, gender, weight, any of those things. So a PEF test is a very useful test to go for, and certainly one that is recommended across the industry as being the most reliable test. When you look at some of the other blood tests, like a full blood count, it would be easier to flick a coin and get a result because it's about 44% sensitive. It's great for health, but not necessarily for picking up alcohol use. A question that has come in is, do we consider the hair color in the reports? The way we interpret our reports is we always consider all factors, and we look at what is going on for the trend in use. So we're seeing a trend. It doesn't matter what hair color someone has if you focus on the trend. Is that going down, up, or staying the same? The dangerous part is where you focus on the numbers and compare it together with 2 people. So yes, the hair color does, and it can get complicated if you're trying to factor that in and compare results between people.
So David, am I right then in saying that the number on its own doesn't really tell us anything?
Yeah, the number doesn't tell you what people think it was. If you're trying to look into this number and you're trying to say, what does that mean for my client? They're abusing a lot of the drugs. There's many reasons why that number could be high. So you have to look at the whole picture, and that's what the toxicologists do by taking all the evidence and all the information and write the report. If you could just look at a number, you wouldn't need the toxicologist. There would just be a very arbitrary figure. You could look at it and it would just be, these are the levels of what you have. You have to look at the pattern. That's really, really important. And if you're using head hair, the pattern is easy because you can get it segmented in one report. If there's only body hair or nails, you have to do multiple tests over a period of time, but it's still all about the pattern. So that's the main thing to consider, the pattern, and also the fact that when you look at a cutoff, if a report says negative, in some cases, someone could have used 9-10 lines of cocaine in a month and still show as a negative test result, depending on the cutoff level the laboratory has applied.
Okay, perhaps we've got time for one more question. I don't know if there's one in there you can pick up on, David. Clearly, your talk was extremely interesting to everybody. If not, can I just say that the clarification about PD5A in the chat is very helpful. Thank you very much. If I wasn't clear about that, I'm sorry, but just asking you to reflect on part 18 because it does apply. With that said, thank you very much indeed to David for giving us such a fascinating insight into toxicology. I know it's generated an awful lot of questions, and I wish we had more time to expand on the debate because I know these are issues and challenges that we face every day with in our practices. So thank you very much indeed.